right, now let us. Rather sorry that you had to wait for such a long time.
No, not at all. No. Let it come on Thursday, my lord.
Today you are not in a position to do it. Today you are not in a position to do.
Today, just my lord, I reached Cuttack around 9:30 in the
Oh,
morning.
it's all right. All right.
That is the list.
It's all right. No problem.
Thursday, my lord.
Thursday. I think you have given a written note of submission.
I have given a written note.
So we'll just quickly run through the written note of submission if you have time today, so that we'll get an override.
My lord, I would like to do it myself on Thursday in a manner I have decided to do.
Okay.
It was before my lord Justice Ratha earlier.
I have seen lot of hearing has taken place.
And she has released it for whatever reason after
Whatever.
keeping about 6 months, I do not know.
I want to conclude it. I was thinking that I will conclude it today itself.
My lord, Thursday you will not.
Okay.
Your lordship will conclude.
Thursday, no problem. If possible, 2 o'clock also you can come today. If otherwise Thursday, no problem.
Thursday.
Okay. Thursday is a first item.
First item. That is in the list. First item.
You also get ready so that quickly we will wind up. Within half an hour, I will also take it. So that within half an hour we will wind up.
Not only the select features I will place in forward. It is a technical matter. So I will place those technical.
So I will expect that you should read it so that technically whatever he is raising, we'll deal with it.
Yes.
Thank you, sir. Thank you. Yes.
Item 47. Item 47 on behalf of Mr. Ponda, my lord. File is not trace out. Let it come.
File is here. You need not trace out anywhere. It is there. You come with the pen drive, take it. Let it be there in the.
And
I'll recommend it.
I will take this
No problem.
sub copy of the entire.
Yes, of course you take.
Alright.
No problem.
My lord, let it come 2 weeks after. 2 weeks. 2 weeks.
Not 2 weeks. It is there. It will remain in the list. Don't worry. I'll not take it up.
Mr. Ponda has taken his mother
All right.
medical manner.
It's all right, sir. Let it be there in the list. I'll accommodate you. Don't worry. If it goes out of the list, then the pressure will go from you. So let it be there so that the pressure continues. Yes. NDPS. It's all right. Yes. Nobody there. No mentioning. Yes. Item 2. Item 3. Item 3. Sorry?
It is a conviction. It is against a conviction. I've gone through the judgment, but I need to go through the witness statements. There are some contradictions. Just short points I will say, my lords. What are the main points which I will rely upon? First is there is an alleged eyewitness of which no TI parade was done. So there is no.
Let us proceed now.
My lords, just I will place.
I'll read the evidence with you. I have also not read it. And I believe he has also not read it. Let us read it together.
My lords.
Let us read it together. If any problem comes, then we'll see.
My lords, I was not well prepared today, but your lordship, as your lordship insists, I will.
The way you started, I thought that you were so confident you started. Let us see.
My lords.
Let us see how things are going. Because these are very old matters,
My lords,
94 matter. I don't want to adjust.
My lords.
Mr. Panda, you are in which matter? You have to wait for some time. You have to assist in some matter if nobody comes. Okay. Yes.
Plus, accused herein is the eldest son of the victim.
Yes.
Conviction under 307, my lords.
307.
My lords. RI for 7 years and pay fine of 1,000. In default, RI for further 6 months.
1,000 plus 6 months.
My lords.
Yes.
Accused is the eldest son of the victim.
Okay.
So the dispute arose.
Father, son.
No, mother.
Okay, mother.
Mother is the victim, my lords. Just that apart, my lords. As on date, my lords.
Let's see what is mother's statement.
My lords.
PW?
2, my lords.
PW2.
2, my lords.
Let us see that.
My lords, just that apart, my lords, just one more information that as on date, the present appellant would have been 80 years. I do not have any instruction because I have been trying to contact him. But as far as the report of my learned senior is there, he is alive.
80 years.
80 years. 80. As on today, my lords.
No, he was 40 at the time of
49, my lords.
40 years.
At the time of filing of this appeal, he was 49.
Let us see the charge sheet. Let us see the charge sheet, then we will come to know the exact days. What is the period undergone? Have you checked it up?
My lords, the last information that I have got in 2022, way back in 2022, that some days he has spent some days only in jail.
Let us find out from the record.
My lords.
Let us find out from the record. We will close it up like that. He is Puri, eh? Puri
Purushottam Behra, my lords.
Purushottam Behra. Purushottam Behra. Charge sheet, when charge sheet was filed, he was 37 years.
My lords.
That is in 93. 93, 37 years means now he must be around.
I have calculated. As on today, he would have been 80, my lords.
No. Charge sheet indicates the charge sheet was filed on 6/4/1993. In the charge sheet it is written
My lords.
that he was 37 years. So must be around
Then 69. If
60,
as per
70
chart
years,
sheet,
about 70
60.
years. Okay.
My lord.
He was arrested on 10/4/1993. Arrested on arrest on 10/4/93. Okay. And when he got the bail, just see. Order sheet you find out. See the order sheet. Bail bond is there. Let's check it up. Bail bond. Bail bond. 1 minute. 93. 19. 19 April. 19/4/93 he got bail. The bail bond he has filed. Only 9 days. 9 days.
Just as far as my information,
Fine.
he last communicated some days. He has
No,
spent
then
some-
let us see the after the conviction, because it is 7 years sentence.
7
So
years.
389 benefit would not have been given. Let us see the proceeding now here. When the judgment? Judgment dated?
Judgment dated, my lords, 16/1/1994.
16/1/94
1994.
judgment. Judgment. Let us see now. (25/1/94) bail granted. 94 bail. This is also about 9 days. This is also about 9 days. This is also 9 days. About 18 days he has undergone total. 18 days. Yeah. He, Jyoti, please come and give some. And Mr.
Last item 40 almost
Give it the file now. Mr. Mahanti, there are very small matters, couple of matters. Yes. Item number 41. Just check it up. where the lawyers are not there. Continuously give the files, read it, and we will do it. Finish. Small matter. Let him just see the files, take it out the files where the lawyers are not appearing continuously. Give the file, you read it, and we will finish it up today itself. Okay. Got it. Yes.
My lords.
So, but the 18 days undergone
18
period. Let us see now the victim, the mother, PW2. you
Two,
say.
my lords.
Schedule 2.
Let us read it. I know the accused is my elder son.
My
In the
lord.
night of last Chaitra Purnima, my husband had gone to guard watermill on the field.
My lords,
Youngest son had since gone to so and so, and the third son has gone to see opera.
para 3 is the relevant, my lords.
Para 3.
I was-
How things are, let us
My lords.
read full so that I can understand. Myself and PW1. Who is PW1?
The
Yeah.
eyewitness or the sister-in-law.
Sister-in-law.
Sister-in-law. She is the eyewitness.
Eyewitness. Eyewitness and her baby were sleeping in our house. PW1 was sleeping inside her room, and I was sleeping in the cot in the veranda. In the night, I woke up after cut blows inflicted on me, but immediately lost sense. Regained Devgarh hospitals. In the hospital, I found that I had sustained one cut blow on my right temple, and the another cut blow on my upper lip, right side of nose.
The only grievous is the
And
neck,
two
my
cut,
lords.
let us read it.
Mm.
And two cut injuries on my neck,
In the neck.
on my neck,
In the right side of
and in
another
the right
cut
side,
injury.
and another cut injury in the
Okay,
left
left
chest,
ear.
near the pit.
Near armpit.
So and so. I do not. I
Do not know
don't know
who
who
inflicted such,
inflicted. I don't know
Such
who
injury.
inflicted the
such injuries on me.
injuries on me, because he was sleeping. That time
Sleeping
injury came.
and,
For the
immediately
last 18, let us see. For the last
16
18
years.
years, accused is staying separately with his family
My lords.
in another house, and he is not talking with us, and we will pulling well before the occurrence. We were pulling well
My lord.
before the occurrence.
Occurrence.
This is important. Huh?
The motive, my lords.
PW is permitted to put a question. PP, hostile or what?
Hostile, my lords.
Hostile.
Hostile.
I was
Does
examined
not,
by the police.
did not support the
It is not
prosecution.
fact that I have stated before the police that due to land dispute, the quarrel of the accused staying separately, and that he was regularly quarreling with me and my husband and my sons. That there was no quarrel on count of forceful cultivation of our land, and it is a fact that so for PW one is my let us see PWC has not supported the prosecution to the fullest.
My lord.
Let us see PW1.
PW1.
eyewitness. What does he say? I know he is the elder brother of my husband, staying separately, and his younger brother, who is the elder to my husband, is also staying separately with his wife. So my husband, his younger brother, so and so, and my parent-in-law are staying jointly in the so and so. On the occurrence took place in night so and so last Chaturmas. On that day night, my husband was not available in the house and gone to see opera. His younger brother, so and so, who is participating with Indonacho, was not available in our house. My father-in-law had gone to
watermelon field.
was so and so. This part is correct. Both the accused are saying the same thing.
Right, my lords.
Therefore, in the night, myself, my baby, and around 5 months at the time, and my mother-in-law were available in the house. This part is also
Same.
corroborated.
Correct.
Okay?
Yes, correct.
I was sleeping inside the room, and my mother-in-law was sleeping in the veranda. This is
Yes,
also correct.
This is also
This is also correct. Now let us see. At about 10:30 p.m.,
short distance out
my
from me.
baby woke up as she was hungry. I breastfeeded her. Heard some sound, but did not give importance to presence
To
of
presence.
cat. Again, I heard similar sound, and
Grown of
and
my mother.
grown
Of my mother-in-law.
my
My mother.
mother-in-law, ground of my mother-in-law. She had heard drilling disease, head drilling disease. Therefore, I
Therefore, I
placed my
placed
baby on the bed and came out of the room with a lantern
lantern.
and found the accused dealing with the one X blow to my mother-in-law. Under my own eyes, he further dealt another blow to my mother-in-law and who was ground. I was what is this? I was
Numbed with fear.
numbered with fear.
My lords.
Seeing me,
The accused fled
the
away.
accused fled away. And I called my uncle, aunt, in-laws to my father-in-law and tainted injury. I reported this to husband. So. Thereafter, things happened.
Yes.
She has supported.
My lords.
Hmm.
But there are some contradictions in cross-examinations. Which
What contradictions?
Lords, the incident that she saw the accused, she held a lantern and she went away and she saw the accused has been not been corroborated in the cross. It has been contradicted. My
Let us
lords.
see which part.
My lords. Just from fourth para, the cross-examination.
Paragraph 4, paragraph.
Fourth para to are
Yes.
both.
And the lantern thing you are saying is para 6.
My lords, para 6. My lords.
I had one burning lantern in my bedroom.
Bedroom with low illumination.
Low illumination. Hearing the
sound, but sound.
sound.
I
I enhance the illumination of the lantern light and look in the
my lords.
Direction.
direction of Duli, where in
Dulli. Where the
when
kitten were staying.
I heard 5 times of the sound, what. Thereafter, I heard the grounding and rust out of the lantern, and lantern was being housed. And it is not a fact that I have stated before the police under 161 that hearing the sound of fell from the bed, I woke up and later. Oh, these are very minor contradictions. The fact remains that he heard the sound
she
and
heard
went
this,
outside,
went
with the
outside.
lantern,
My lords.
rising the illumination and saw that the accused was giving blow.
My lords.
This is what is the consistency.
There are further what will be extracted further, my lords, that there was no identification, no TI period of the accused. Further,
Why?
the
Brother-in-law, what TI?
that apart, my lords, the incrementing weapon, the axe that they say that the present accused had inflicted blow and has caused such injury was never seized or never taken into.
That is one part.
That is one part.
But why will you doubt this eyewitness?
Let's
If the injured witness says that I was sleeping, somebody came and given the blow, and he describes what are the blows, and that directly corroborates with each and every line, corroborates with the PW1. Let us see the doctor, who is the doctor, whether the corresponding injuries are there or not. These are the 3 witnesses enough for 307. Intention is already there because there is a land dispute.
But
you are you are attacking your own mother.
That
means there must be intention.
That intention has been negated by the mother itself, that they were pulling well. There was no such motive. The motive, the mens rea that has to be there has been negated, my lords.
If the injuries are simple, then we can convert it to 323
EW
or
10
324.
324.
If intention part goes.
Let's see. Grievous injuries. There are grievous injuries. Grievous injuries.
Doctor, who is
PW 10, my lords.
PW
10.
10. Let us see. Yes.
There are in total 5 injuries, my lords.
5 injuries are there.
Your first 4 are simple and last one is grievous, my lords.
Grievous. In my opinion, the first 4 injuries are simple.
Simple in nature
and might caused by the sharp cutting weapon, and the last injury was grievous in nature and might have caused by a sharp cutting weapon. What are the injuries? Upper lip. She says that in the lip there was yes. The extend the oblique blow on the parallel of two injuries. Insides injuries, interior. Incisions means the upper line fracture of frontal bone of side of face. The face, lip, and see corresponding injuries are there.
Lots of upper lips,
All
right side
injuries
neck, right.
have been
There.
caused, on the day of the decision. See, the last portion of the examination, she read it, doctor. It says, had the
Weapon of
weapon of the
offense.
injury of the last injury cutting in the frontal bone,
Lots.
had the injury the brain material under the bone, her life would have been danger. What he says is, if it would have been in the brain side,
Yes.
frontal brain side, the life would have been danger.
Danger.
That means you can interpret in this way that the injury, fourth injury, which is the grievous one, is not life threatening. Had it been little different place
Place.
near the frontal region, it would have been danger. Now, what he is trying to say, the doctor is trying to say, it is not life threatening. In the ordinary course of nature, death would not have caused. This is what his opinion is. If that is the case, then how will you bring 307?
307.
And for the face of it, the injured herself says that they were pulling on wells. So it is not a case of 307. It could be at best a case of 324 only. It could be at best a case of 324. IP 324 maximum sentence क्या है? ये IP के ऊपर let us see the reasoning of the trial court. What are the reasoning?
Internal page 15 minutes.
Para 10 is the reasoning, and it has taken note of the defense also. Well analyzed appreciation of evidence. Para 11, para 10.
That's prior to that para 9, I wanted to show you lots of
Para 9 also I read it, but
Para-
para 10 is the real.
That's the motive what I said, Milots, is on para 9. What has it has been discussed? Just I'll read the
No, but the defense is main eyewitness, PW1.
Milots,
Had no good relationship with
why I
him
say Milots, there
because
were
of the property dispute and all, but that was dealt with the trial court and gave a reasoning.
Milots, apart from PW1, there were till PW8, there were independent witnesses.
All the CPW.
All PW2 to 8, 2, 3, 4, 5, 6, 7, 8 went hostile and did not support the case of the prosecution, my lords.
PW
PW 2, 3, 4, 5, 6, 7,
3,
4, 5, 6,
5,
6, 7
6, 7.
did not support the prosecution witness. 8 and 9 were the Caesar witness. 10 is the doctor, my lords.
8.
And 9 are the Caesar witness.
They
They're the mere Caesar witness, my lords.
okay, witness.
And 10 is the doctor, my lord.
10 doctor.
Lords, the independent witness who have been examined did not support the case of the prosecution. Only PW1,
PW2 is the victim.
victim, my lords.
Victim.
PW1 is eyewitness.
Eyewitness. Or the
See, the entire case rests on PW.
Millards, my only
PW1.
why there was an admitted case that there was some property dispute within the family, Millards. Hence, the statement of the PW1 can be she can
No,
be
but
an
the PW1
interested
that
witness,
immediately
Millards.
when he saw,
Millards.
he called
Uncle.
aunt
No,
in-law.
after uncle, even 2, 3 that the uncle falls within these 2 to 7, my lords. They
Who
did
is-
not see the occurrence.
who,
They all are hearsay
which
witness,
witness is that?
Millards.
The uncle and aunt, immediately post occurrence witness. Let us see how they-
Millards, may kindly see the judgment page, para 7,
Let us see the witness.
Millards.
I was sleeping in my house. I woke up hearing Allah and proceeded to the house. And found her lying with a pretty injury in the veranda and PW complained. to
Your
me
lordship may see from PW3,
PW3, yes.
3, my lord.
I've seen it.
He was.
There is a complaint that the accused has.
I was sleeping. I woke
inflicted-
up hearing hulla and proceeded to house and found her lying in blood. She did not. He did not see. PW1 complained that the
He is
accused.
the informant. He is the informant.
Yes, he is informant, my lords. But what is his version, my lords? The third line, PW1 complained to me that
I know.
accused had inflicted, my
Yes,
lords.
yes.
So he was not an occurrence to the witness, occurrence to the incident, my lords.
Post occurrence witness.
My lords.
Mm.
All the witnesses that have been examined, 2, 3, 4, 5, 6, 7, none have seen the occurrence, my lords, or the incident.
No, it is obvious, my lord, because
Only one.
Only one.
There is only one eyewitness,
Only.
and all other witnesses are post occurrence
Post-occurrence.
witnesses.
First.
They have supported the version that immediately after the incident, when the PW1 called them, they came.
They came.
And by that time, the injury had taken place. That
And
accused has fled away.
If
They
they
were not killed.
all are hearsay witness saying that PW1 said them this.
Naturally, because he is only eyewitness.
Millards.
Naturally. And all of them, they have supported. How do you say that PW 3, 4 not supported? 3, 4 supported in prosecution.
No, I say they are all here witnesses. Hearsay
That's a
witnesses.
different thing. They are not declared hostile also.
No, not hostile, Millards. They are all hearsay witnesses.
That's right.
Millards. They are all hearsay witnesses.
These two, PW2, 3 and 4 also post occurrence witnesses and
Millards.
hearsay witness,
Millards.
according to you.
Millards.
None of them are hostile, sir.
No, not hostile, my lords.
Only 6 got hostile.
6 and 2, the victim.
6 is only, no. 2 and
6.
6 hostile.
Even 7, my lords.
7 also?
7 also, my lords.
Okay. 7 also. Okay. Hostile. You know, 324.
Millards.
And converted to 324. It is a case of
Yes.
324. Not 307. His
Let's-
age is now 70.
More than 70.
As far as my information, last I had in 2022, he said that he was around 65, 67 milots. Sorry, 77 or 75 milots. So as far as my information, as far as records goes to so milots, I had calculated at 80, but your lordship has seen the charge sheet milots.
Charge sheet
sheet.
is 37. So therefore,
Milots.
generally what happens, charge sheet may not be correct in the sense the police asks what is your age, he says whatever. And these villagers and all, no, these people are like that. They'll say that yes, this is this, they write it.
Milots.
Date of birth is written, then I can understand. Date of birth is not written. Only
No date of birth.
But he must be more than 70 now.
More than 70 milots.
He must
Because
be more than 70.
last I had talked, he was an old person, only on over phone, and now I am not able to communicate with him.
If
Yes.
you ask, he is ready to go to jail.
No, my lads.
So what yes,
Maximum 72. Age is 72.
72.
Let's may consider of the
See, the situation is
Is
increasing fine will also suffice no purpose because these people, very poor people maybe.
for people.
Sentence is 7 years, I don't know. Why
7 years. My lads.
This kind of evidence.
7 years and 1,000. Fine.
It's disproportionate, complete disproportionate. If I'll impose any sentence,
Milots, if your lordship is taking a view that 324 will be applicable, your lordship may consider the Probation of Offenders Act, my
that's
lords.
what I'm thinking.
Considering his age, my lords.
So,
I'll reduce the sentence to 1 year. Okay. I'll reduce the sentence to 1 year and then give probation.
My lords.
Hmm?
Lords.
Reduce.
Your lordship may
Lord-
only
Lordship may kindly say, Lordship may section 324. It could not be converted to 324
Hmm? Why?
because it is a
it can, my
it's
lords.
hot.
Hmm.
That was why.
Tell me.
There's a judgment of Justice P.K. Mishra, my lords.
325 you are saying. If there he is right. If simple injury with
One
dangerous weapon
Dangerous
is
weapon-
324. And dangerous weapon with grievous hurt is 325. 325. You are correct. You are correct. What is the sentence that 325?
7 years.
7 years. Maybe extended to
Extended it to up to 7 years.
7 years.
And shall also be and fine, na?
Yes.
And-
So fine. I'll reduce it to 325. We will make it 325.
ঠিক আছে।
325 IPC and the reduced sentence to 1 year plus fine. Let the fine remain as it is.
Yes.
Fine amount remain as it is. I'll reduce the sentence to 1 year
Yes.
and because of his age and all, I grant probation. What do you say?
Well, that is possible.
72-year-old man, why he will be a burden on the state? You have to take him to hospital and pay money and all. What do you say? You just think.
High amount of energy also.
These poor people, where from these people get to increase?
Yes.
We'll see. I'll see.
320. Minimum
I'll just see. Sentencing, I'll see. What is your full name? I'm so sorry.
Shubham Sharma.
Subham?
Sharma.
You argued very well. Now some matters I'll point you as a matter. So that's not. Very good. Thank you very much.
I'm grateful, man.
Ravi Didi, I'm sorry. Thank you. Yes, yes. We were waiting for you.
Sorry, man, I was a little late, man.
Oh, sorry.
The other two cases, they have been acquitted. That Ganapati Nayak was convicted and period undergone. I am similarly put with those two persons who have been acquitted.
That is that 319.
Yes, that Visway and
Okay, what happened to Ganpati?
Ganpati has been convicted 307 and this honorable court was pleased to pass the period already undergone.
What is the period?
That might make more than 2 years.
More than 2 years undergone. How much you have undergone?
I am 2 years 22 days. But I am by virtue of 319 I was convicted. Those two persons who have been named and charged sheeted, they have been acquitted. It is in our judgment matter.
Let us see.
Yes.
If they are acquitted, then you are also entitled for it.
25, I am in better putting. 25-7 to 7 is a judgment matter. This honorable High Court.
Yes, Subhalakshmi, what do you say?
It is a letter.
Yes. I'll tell you if I am correctly remember you. Correct
It
me.
is called marriage.
Correct me, but the facts goes like this. One Ganpati came along with 3-4 person. And Ganpati fired a bullet.
Yes.
And it did not hurt anyone. It
Hurt the wall.
Hurt the wall. And charge sheet was filed saying that it is a false case. Closure report was filed.
Yes, sir.
Despite that, the trial court took cognizance against Ganpati and 2 other people.
Others.
That is Gokul or something, whatever. 2 other people, they've taken cognizance. And the matter went on. At the stage of trial, some evidence, according to the prosecution, has come. Therefore, the application was moved on 319 and this gentleman was summoned.
Yes.
And the fact remains that he was held only accompanied Ganpati, like the other 2 people. Ganpati is now convicted by the trial court, and this court has converted the sentence to already undergone. Ganpati story is gone. And the other 2 people, those who really accompanied, against whom the cognizance was taken, they were acquitted. And he is summoned under 319, equally the same role,
Yes.
because he accompanied Ganpati. Then he is entitled to acquittal if the other 2 persons are acquitted. Same set of evidence.
Ganpati was the main accused.
Ganpati was
Yeah.
the main accused. So it's the complete acquittal case. This is what is the case,
Yes.
Yes, sir.
Yes, I have.
as I understood.
I have also read.
If you want to add anything, you can very well add. Otherwise, we will conclude it like that.
So conclude. I have read.
If you want to say anything, you just see. Where from I'll get that these 2 people have been acquitted?
This is that judgment is connected record.
Connected case?
251 of 90. 51 of 90.
Okay.
It is there, madam.
Soft copy.
Yes.
Let us see. It was a separate trial along with Ganpati.
Yes.
Along with Ganpati, they face the trial.
Yes. My
Hmm.
case is split off.
You face. In his case, let us see any evidence. But obviously, that is, in his case, some evidence might have come, but the fact remains that these 2 people are acquitted. The same investigations, everything same.
On the last date, I was with a decision married. It's the same set of evidence. The other person is acquitted. This is to be acquitted.
You are bound to be.
Madam, it is page 6, madam.
They Gokul Chandra, Praful Chandra, and Ganpati.
Gokul Bisway, yes. Praful Naik and Ganpati.
They face the sessions trial 25 of 89.
89 minus 89A.
Yours is?
25 by 89A.
No, your sessions trial is?
That A merit. This since split up. This
A.
is 89A.
A. Okay. Let us see the reasoning there.
But I was submitting since the first day marriage. This is there. This is there, madam. All the attributed to Ganpati.
No, obviously.
Even this honorable court has 506 is not also attended. Paragraph 8 is the relevant. Eight, nine. Paragraph 8, 9.
ज्योति ये जो शॉर्ट कॉपी अच्छी है তার জজমেন্ট কপিটা করে দাও এটা যারা অ্যাবাউট 5 6
5 to 9.
7 पेज खाली जजमेंट तेरे थे अच्छी जो ये करेक्टेड मैटर जो सॉफ्ट कॉपी थी खाली जजमेंट कॉपीটা प्रिंट आउट कर दो ठीक है अब जनता को सेंटेंस करता 4 years सेंटेंस करते नहीं
Yes, 4 years for 307. Acquitted all the appellants from 506. Only 307 convicted that Ganapati. This honorable court.
because he has fired the gunshot
Yes.
aiming at PW4
In
to
this
kill.
case, PW4 my lord. My case PW3.
3 not 2. If you print out the I think it's a case of it story also the evidence also goes like that see PW3 if you read in his case no 1 minute 1 minute David देगा पढ़ा निकालो कितने
कौन सा नाम है?
जयराम पाइको
let us see PW3 here in this case what PW3 says in this case
PW3 man page 71.
71
Main case. कौन सा मैच है?
71
मैं रीड में
नहीं 1 minute 71
71 in the main case.
70 this
Yes, that
PW3
3 man.
No, 71 it's something different. It is the other case. Oh, it must be here. 70.
Page 71.
PW3 is what is the name?
Panchu Singh Maji.
Panchu Singh Maji, right? Yes.
I know all the accused persons.
Occurrence took place in residence. I was sitting in the chair. Before Varna, my front house. My wife PW1 and the daughter PW2 taking also. All the accused persons came to my house and accused Ganpati fired the gun. Hit the wall and covering so and so. He's only said that.
Yes.
Ganpati.
And the
That's-
PW2 is his daughter married.
He has not taken the name of this
No one else, only Ganpati.
and PW2.
PW2, his daughter is saying only about Ganpati. Also, she is saying nothing about others. Only Ganpati came.
Yeah.
Ganpati
Accused
came
Ganpati fired the gunshot.
Ganpati came to my house being armed with a gun. Accused Ganpati fired a gun aiming at my father.
And left the body and
After
fled.
firing, left the body.
And-
He is saying
and-
nothing about.
Neither the PW2 nor PW3. They are the
Yes,
witnesses.
yes. PW1 is his wife.
चलो जी जी केस है पिता दे दो ये दो
Obliged.
अभी दे दो थोड़ा बहुत ठीक है यस
Item 4. Item number 8 may be taken up with a small matter.
यस सर
There are 4 appellants, father and 3 sons. Father now may be dead. If alive, he will be 84 years old.
50 years we have called for the report
No, in this case, and the sons are, 2 are above 60 and 1 is 55. Father is mostly 84 now. The cash sheet, he was 50 in 91.
yes must be 80 and the rest of them
That's all.
2 3 4 are 20 25 years and 26 years they must be about 50s
They are convicted.
what is the case
Convicted under section 452 and 323. Initially charged under 452 and 302. But the medical evidence revealed that the deceased was a chronic heart patient and died of heart failure, not by any assault. And there was no evidence of assault. The learned trial court has also recorded that there is no direct or circumstantial evidence of assault. But doctor has found some injuries on knee and shoulder and says that must be due to result of some assault. That was consistent with that doctor also said that with fall. These injuries could be caused by a fall.
okay
And he was a habitual drunkard. And and the other allegation is they dragged him out of his house and took him to the outpost. There was a quarrel. Let me give the.
then you are sentenced to
1 year RI, no fine. And they have exactly 3 months they have been
undergone
undergone. Exactly 3 months. On 3991 forwarded.
are you pressing for an acquittal or undergone tell me
You're undergone.
Lordship, I have no objection if the period undergone, Lordship.
period undergone see 94 incident
Yes, sir.
323
One
and there is no injury as such
But if you do one,
No assault, no evidence.
One
no
that
assault is there
No assault.
injured 189 has supported the case of the prosecution, but
That's right.
I am not disputing. Is the keeping in mind
let
the
us,
age of the
let us
appellant?
see sir you just tell me when they were arrested
arrested on 3991. That should be available in at page 4.
91 arrested.
Yes.
I go by what you say.
And bail granted on 31/12/91.
31?
12/91.
91 bail.
Thereafter, they have been on bail during trial and
3 months, exactly 3 months.
exactly 3.
Let us verify this fact. Verify this fact. Come to the PCR.
Page 497. you will-
Let us see the charge sheet. Huh? Let us see the charge sheet. These people were arrested. Charge sheet arrested. Where from you got that they are arrested on that day? Same day?
Not on the same day. The FIR was lodged after 8 months. There was some controversy regarding the
8
original-
months FIR.
Yes, there was that also by the police officer. The victim's wife lodged stated to have lodged initially one FIR, which was not properly registered by the police. There was a controversy. Wife complained to the higher authority, and
When the incident happened, sir?
incident happened on 31/12/90 noon.
That-
Noon first there was an altercation, and in the evening they came and dragged him.
That's all right. But when the incident, according to you, 31,
31/12/90.
12, 90.
Yes.
And FIR?
FIR is 25/8/91.
Baapre.
And that too by the police officer.
They were arrested then
They were arrested on
30th. Where from you got that? They were arrested.
Page 497 order may be back. That LCR. Page 497.
Proceeding
Yes.
of the court. Okay.
They are forwarded on that day. Order number.
You may not be correct, sir. If you see the no, 93. Okay. You may be correct. Arrested. Where from I'll get the arrested? Mr. Manti,
Yeah, Lords, I am very kind.
if you will not contribute and I'll go by his statement.
Lords, sir, I am,
I will not make that level. It is you who has to tell me. Otherwise, I'll take it that they were in the custody for about 3 months.
can date of birth, which is-
Bail bond.
1994, 16/2/94.
Bail bond is 31st December 1991. Bail bonds are there. Only date of arrest is just verify.
He was remanded to till 11/10/91.
Bail to grant.
First remand.
It is in for 98 case now. In order determined 31st September. 30th September it is in forwarded and remanded to 11/10.
When date is written?
Yes, yes.
What is that? When?
Page 497.
Hey, what is the date? I'm not able to
Order
find.
dated 30/91.
What does he say?
The case record put up today as IO forwarded accused person, namely.
There is no economy. Then there is no economy arrested. And bail is there. Bail bond is on 31st December. That's there. It's correct. That's correct. So I think undergone.
Yes.
If you are aiming an acquittal, then I'll read it.
No, see, apparent one must be dead by now, and others, I have no contact with them since last.
Undergone को छोड़ दो.
Also in that order, it is written custody since there is no economy. That
अच्छा.
31st order, man.
Sufficiently punished. But it is see, the FIR is after 8 months.
Yes.
See, how the trial court deals with the delay part. See.
Page, para 7. We are dealt with that controversy regarding the past exercise.
He died, huh? Died of what? Natural death.
Died of heart failure. That is the
Heart
evidence of the document.
Then, therefore, 302 was registered, therefore, you were taken into custody.
Yes.
And UD case was also registered.
UD case initially was registered because he was drunk and fell down. That was why UD case was registered by the police at the first instance. But the wife complained to the higher authorities. Then another police officer was deputed. He lodged an FIR and took up an investigation after 8 months.
That is phase 3. This is explained. Sumitra is the wife of
Deceased. The allegation was initially changed by that police also to register an UD case.
The deceased statement was not recorded. He died.
He died at court. Then before police came, he was
By
already
that time.
dead.
But he appears to have told it to his wife that he was assaulted by the accused.
Yes, that is
That is the only
only
incriminating.
statement by the wife. Nobody has seen any assault. That is also the observation of the that there is no circumstantial or direct evidence of assault. But because there are some injuries found, it found it to
323.
Yes. But injuries were due to fall that act. And assault injury cannot be on knees. It is on yes, chest or belly. There is some evidence of dragging him to the outpost. That is, we were taken to the outpost by the This appellant is admitted. But whether you are dragged from inside the house, that is not clearly true. Because the wife and a neighbor, there are
The
two.
fact that he was dragged by the accused persons from the house is stated specifically by PW1, corroborated by PW 8 and 9, the neighbors.
And one of
Therefore, the
the neighbors,
intention of the accused
against whom
persons
there is a
is from
criminal case by the accused persons.
drag Lal Singh from his house.
So, interested witnesses, two interested witnesses tell about the dragging from the house.
Therefore, 452.
452 also doubtful. Dragging only.
But the trial court says that is well established. That's what.
Yes, trial court, because of the evidence of the wife and
PW2 and PW1 and PW 8 and 9.
8 doesn't say. PW, PW 9 doesn't say that you were dragged from the house. He only said that he saw that they were holding a hand, two sons are holding both hands of the victim, not inside the house, outside the house.
Outside the house.
And only one.
Dragging towards the outpost.
Yes, and that is admitted. They took him to the arch because of an earlier altercation in the noon. 1 and 8 only say that dragged from the house. And 1 is the wife and 8 is the neighbor against whom these appellants have a criminal case. That is admitted by him in his deposition. Those two are interested witnesses. So 452 is also doubtful. There is no clinching evidence.
Aberrations on the left knee joint. Aberration on the left knee joint.
Left knee, right, both knee, and then left shoulder. And other is this hip area, which is consistent with fall. And he was a
chronic heart patient, huh?
yes. And doctor could not smell any alcohol.
Alcohol also.
Because he has explained that within 2 hours stomach becomes empty and smell vanishes.
Where is the cause of opinion was not evidence. Cause of death is
It will.
323 is also not made out in true sense.
No.
Because the evidence is nobody has seen. The court also says that there is no evidence.
Yes. But because there are so many
regarding any assault being made. 323, how? He's not made.
PW1 says she has seen the person dragging.
He has not seen dragging. There is no assault as such. This is.
PW1.
Only dragging part. That is 452. That is 452. Where is 323? Where is assault?
We don't know what says. My husband quarreled with Trinata on the issue of drainage of filthy water in front of my house by the accused persons. I have seen the quarrel. Ugrasena intervened and took my husband home. Everything was quite calm. In the evening, again, these accused persons picked up quarrel with my husband, dragged my husband from the house outside and took him away, stating that they are taking him.
Dragging, I know, dragging is corroborated. Therefore,
No,
452.
so this is the last scene.
Huh.
Thereafter, in the night about 10 to 11 p.m., the accused person brought my husband to my house and probably dropped him in front of my house, which I have seen. Since there was none in my house, next morning I went to call my nephew and carried my husband inside my house. At that time, I found blood coming out of the mouth of my husband. He told that he was being assaulted by the accused person.
He told that part only. Nobody is seen. That's what the trial court says. There are only circumstances.
The accused person dragged him out of the house.
Right, but
He was brought along with the injuries, and he said that he has been assaulted and he is found dead.
but it's a case of.
And you will also decide accused was examined 8 months after the incident.
That's right, but
So-
that is explained.
No, so there are the chances of embellishments. That is what I am saying. That they made up of that.
Keenly, if you see, it can be a case of acquittal. Keenly, but now since you are made up the mind for already undergone, why to do? I was just looking at this evidence because if it's a clear-cut case of acquittal, then it was a different story. Now undergone 3 months. Huh? Where is that? 3 months FIR.
320.
Opinions ಇರ್ತದೆ ಈ ತಿಂಟ ಬಿದ್ದಿದೆಯೋ ಸಂಖ್ಯಾಂಕ ಅಲ್ಲಿ ಹೋಗಿವ ಸ್ತ್ರೀ evidence వచ్చి PW1. Who is the doctor?
Schedule 4.
PW1, 4, 8 and 9. 1489. Yes.
Lordship, some of those matters, my lords, let it be rolled over. Suppose if the learned friend is not coming, my lords, I will fix it day after tomorrow.
Yes.
I have given the pen drive, my lords.
That's right.
Grateful, lords.
Yes, sir. You in which matter?
2-3 minutes. So they are
2-3 matters. Item numbers?
7, 15, 17.
7. Item 7, 94 and
15.
96. Yes.
17 is 97.
Then if you are ready at 2 o'clock, then I'll take up your matter. 2 o'clock, all these matters. Already undergone period, just find out if we can. Then 2 o'clock I'll start hearing. The 3-4 appeals I have heard now, I'll give dictation to that. छोटो मेट्रो कोई item number small matters.
41 or not?
We can do it. Small matter, which Manti is there, and Mr. Vishra is also there. Small matter, if you can finish up, small sentence and all.
3 months,
Good
6
try.
months.
Take it. Wherever see period undergone time, and wherever PO we have to bring. Recurring ticket. For this, so that if not today and Thursday,
Day
all the matters we can finish up. All the
tomorrow.
Day
7,
after
8,
tomorrow,
whatever matters are there.
Lords.
Just check it up.
Yes, day after.
Thank you. What is it?
appeal of 2009. I do not have the brief. This is lost now. I have taken the NCR up to date. What I made, 2 weeks time for preparation. It will be there. After 2 weeks, I'll take it. Don't worry. Note कर दिया. अरे आओ सर 2 weeks कर लोगे तो we'll be free at least. 2 weeks कर लोगे.
I may pardon, item 2728, small matter, I am ready, it will be taken up on Thursday.
Let me see. After this point. 27?
2728, Thursday, I think.
Thursday you want, huh?
I am ready Thursday. It is in the list. I just mentioned it. will
Oh,
be
okay, it's
taken
all
up
right.
Thursday.
Let it be there. And what about the other small matter?
51 got also, sir.
Item 10 also. Just see.
51.
No, you think about first 94, 93. Item 8,
9, 8, 9.
you just
10.
see 10, huh?
8 reserve
Huh?
8 reserve
8 reserve. Just see 10, huh? 10 we will finish it up today. ठीक है 323 okay ten 9 and 10 just see
9 does
9 and 10 I'll hear this and thereafter 9 and 10 so somebody should just go through and just see if the lawyer is there Mr. Mishra is there just see Mr. Mishra 9 10 if nobody is there then you have to do it small matters 349 Venkatrao. Then
No, that's a
Why don't we take up small matters than this?
7 we will start whichever
Ballot.
you are ready
Ballot.
I am only targeting 90s matter
This is 94.
we'll do it.
If it can-
Get ready, Mr. Mishra. Just see 10, item 10. Huh? I'll just, yes. Item 10 to file the.
9
Yes, sir.
Ballot. Here.
7.
Seven.
7 we are doing. Yes.
Ballot.
7 to file the.
Wait,
Yes.
Here, ballot, the appellants, initially the 2 in numbers. Ballot, instruction says ballot appellant number 2 is dead in the meantime.
Appellant number dead, huh?
Ballot.
Okay.
They were placed under trial in the court of this additional session judge ballot, and they for the offense under section 307/34, and they have also been convicted for the said offense and sentenced to undergo RI for 5 years. As per the prosecution case, FIR was lost by PW1. The occurrence has taken place in a talkies cinema hall called
You said appellant number 2 has died.
Ballot.
Whether it is abated or no?
Appeal is to be abated.
No, there is no order of abatement.
No money. Yes.
Okay. Okay.
The order has been passed.
No abatement order. Then we have passed an abatement order. Huh? That legal statement, it is brought to the notice for this court that appellant number 2 in the present appeal.
That is as per the
No,
instruction.
it is abated already.
Ballot.
24/4/2023 abated.
Ballot.
Okay, it's all right.
Ballot,
Yes, sir.
the occurrence has taken place in the cinema hall after the second show was completed. That cinema hall is Ramai Talkies, Balangir Ballot.
Hmm.
PW1 is the informant who is the manager of the set of. He said after the cinema was over, it is alleged that PW3 was surrounded by the present appellant and the person who was died, Raghav Pradhan, and he was assaulted by them. He has not named any accused persons in his affair. PW's 2 and 3, that the 2 persons, those who have
You are
seen PW2 is the
Madhusudan
brother of PW3,
Madhusudan Pradhan.
Mallet.
Let us see PW3 now. Let us-
My lord, injured.
Yes. Yes.
I know the accused persons. This incident took place on 14/4/93 at about 11 p.m. Well, let me kindly take note of 11 p.m. in Ramai Talkies premises. After witnessing the second show, police and Mujrim, the name of the film, when myself and my brother were coming out of the premises of cinema hall, the accused persons attempted to assault me, but I managed to escape from that place towards Delhi Market. They chased me and caught hold of me at a distance of 100 to 150 cubits from the cinema hall. The accused Raghava caught hold of me and the other accused dealt 2-3 brutally blows on my body. However, I tried to extricate myself from the clutches of the accused persons and managed to come away and enter inside the cinema hall premises. When the assault was made by Bhujali inside the cinema hall premises, I fell down on the ground. They also assaulted me further, even after I fell on the ground. I sustained several injuries on different parts of my body. I was treated in the hospital for 20 days, but continued the treatment for 3 to 4 months. I was unable to move even during those periods. With the assistance of others, I was performing my routine duties. Still, I am feeling uneasy while working. My right hand is not working properly. I disclosed the name of the assailants and also my name to the staff of the cinema hall. I was removed to the hospital and lost my sense on the way while taking to the hospital. MO1 is the Bhujali Kukri, with which I was assaulted. There was profuse bleeding from these wounds. MO2 is the pant, MO3 is the t-shirt stained with blood. While assaulting me, they were shouting to kill me, thinking me to be dead. The accused persons left the place.
Yes.
Well, this is the case.
So then there is nothing, no overtake is attributed to Madhusudan. Specific overtake. Because we are only testing Madhusudan case.
Alert.
Madhusudan is the appellant number 1.
Minor.
No overtake is attributed to him by this witness.
No, overtake is attributed to him also.
Accused persons.
Accused
But
persons.
no name is not taken.
Valid. So, my lord, here is a case.
But Raghav name is taken.
Valid.
Very specifically Raghav name is taken.
Obstructed, yes.
But not his name is not taken. How many accused were there initially?
2 valid.
Only these two.
Two.
Okay.
Well, the background of the case is, it was suggested and also he has admitted, and the accused statement also, accused persons have stated, this accused, this witness, PW3, has kidnapped the sister of the present appellant, and it was, the case was registered, it was subsided by interference of the villagers, and after that, the proposal of marriage was given by the accused, which was refused by the
This
appellant,
witness.
which was not turned down by the appellant, for which there was a long-standing enmity was there. And another case is also pending against them by the time this occurrence has taken place. Enmity is admitted because that was suggested, and that also accused persons have also stated there in the same in their accused statement. Well, the injuries sustained by the PW3 as stated by PW7 by the doctor are 13 in number, 14 in number, and out of the injuries, injury number 1, 8 and 10 stated to be grievous, but not on the vital part.
Who is the doctor?
Doctor is PW7.
7.
My lord. Dr. Narendra Kumar. So
13, 14 injuries.
14 injuries. No, not on the vital part of the body, in the left knee, this
Simple,
right knee.
excepting injury number
1,
1, 8 and 10.
1, 8 and 10.
Which are grievous.
Incised injuries above right ankle, incised wound over the front scalp, incised wound over right elbow. 3 injuries are grievous in nature. But admittedly, the injuries are not on the vital parts. X-ray was, as per the doctor, X-ray was done as per his advice. He has referred the X-ray plates at the time of treatment, but that X-ray plate has not been exhibited. Dr. Tripathi has scribed the observations with regards to X-ray plate as per radiologist opinion,
X-ray plates are not exhibited.
not exhibited. Dr. Tripathi has also not been examined. Peculiarity of the case is, my lord, I was saying my learned friend, competent advocate, that here is a case, affair was lost at 10:45 p.m.
Incident has taken place at
10:45 p.m. madam, 11, so to say.
11.
Madam.
Hmm.
As per the case affair story, my lord, we see page 26. So 28.
Hmm.
Time of closing of affair 11:05 p.m. at spot, 11:30 at the PS. So
That is at 11:30.
10:45. At about, I like to, PW1 has stated, I like to draw your kind attention that at about 10:45 p.m. today, that is on
PW?
1, that is affair balance, recitals of the affair,
Ah.
third line,
Ah.
10:45. What has actually happened in the present case, which has been
See, for 10, 15 minutes here and there.
10:45.
Nobody watches, nobody see the watch and
Huh.
10, 15 minutes here and there makes no.
10:45.
It's 10:45, it's 11:05.
My lord.
Only-
So
only 20 minutes.
what I want to say, my lord, PW1 says after he, observing the same, I sent my worker Ramkrishna Swami to go to the police station to intimate this incident. PW6 says, I received a telephone call, I made a stationary entry and sent one Mr. Pradhan to the spot.
Hmm.
Pradhan has seized the weapon of offense and handed over the same to PW4. Pradhan has not been examined. Well, let me see PW4 paragraph 2, 6, 7th line, 3, 3, 6, 7th line. MO1 was seized at 10:30 p.m. If the affair was lost at 10:40, occurrence is 10:45, affair was lost at 11:05 at the spot, how could the weapon of offense, alleged to be a Bhuzali, was seized at 10:30 p.m.? And PW4 is not a private witness, but he is police personnel, ASI.
Yeah, half an hour here and there, all these things, stories.
My lord?
Half an hour here and there.
Yes, well, he says 10:30. That is on record on
He's
in chief in the cross examination.
I've seen it. It
Madam.
says that
And that too, this
MO1 was seized at
MO1,
10:30
yes,
PM. For the date
MO1,
of occurrence.
MO1 was seized,
Hmm.
but how it was kept and how it has been sent to FSL for the test, it's not there.
Serial.
It's not there. Admittedly, this PW5 has also stated NBT is there. Not a single with
Who is
independent
PW5?
PW5 ballot is the well, let me see this statement. I got telephone message about a quarrel at 10:55 p.m. in the PS. The ASI entered the fact in the SD by SD number 961. I have not seized the relevant stationery during investigation. I have not seen Surendranath Pod said to have been sent to the PS. It is not a fact that I made Surendra Poda at the PS. I came to the spot in a scooter along with him. I do not know if PW1 had gone to the PS to request the IIC to send police personnel. It is not a fact that I have suppressed the report of Surendra Poda and the SD entry, except the cinema hall. My lord, here I want to say I could not get my learned friend got exhibit 10. Court has exhibited exhibit 10 by the sustenance entry, but who has produced it and how it has come to the light, my lord? Exhibit 10. My lord, it is not a fact that I have suppressed the report of Surendra Podho and SD entry, except the cinema hall staff and the injured, none else was present when I arrived at the spot. Narendra Panda and Podho and Kandrappa Sai, VW1, were present during my spot visit. They are witnesses to the occurrence. There was light outside the cinema hall. There was shops near the cinema hall. Some shops are running in wooden cabin. I have not prepared the spot map. I did not accompany the injured to the hospital. What I remember, the medical staff brought out the MOs 2 and 3 from the body of the injured. The scissor was affected in the hospital. Dr. N.K. Sahu
What do you want to bring out of it?
My lord, I want to say,
See, apart from the timing factor,
my lord,
10:30, 10:45,
and my lord, the alleged Bhujali,
11:05.
alleged Bhujali was not produced before the court. Bhujali, and they say a kukri was produced as above one. That Bhujali which was seized, IO says it was covered, but that cover has not been produced before the court. These all small things, my lord, but fact that there was an occurrence, fact that some PW3 has received injuries, if the intention of the appellant will be taken into consideration,
The incident is admitted on
on
record, proved.
it is
And the injury is sustained by proof.
PW3
And
is
see,
admitted.
how will you escape out of it?
No, I am
Even
not-
if
Here only I can say, my lord, the injury.
what is the period undergone you come to?
Intention was not to do away with the life. 307.
Intention you can't escape because for the past enmity, the kind of enmity you see.
No, my
the
lord,
gro- sister-
if the intention was evident in that, or the injuries would have been given to the vital part of the body, intention of do away with the life would have been there, my lord. Here,
Let us come to the doctor once again. What that in the ordinary course.
PW7,
Where is that PW7?
my lord,
Let us see carefully that part.
my lord.
You want to bring it to 325.
Yes, that is by sole
Let us see,
individual.
let us see the intention, whether what doctor says.
My lord may see that. All the injuries are simple. Page 54. All the injuries are simple except injury number 1, 8, and 10, which are grievous. I examined the injury at 11:15 p.m. on that day and was within 2 hours. All these injuries are possible by MO1. Exhibit 8 is my report. Exhibit 8 by 1 is my signature. The patient was admitted to surgical ward as an indoor patient, so and so. Individually, none of the injuries were fatal in nature. I instructed to give the wearing apparels of the injured to the police. OIC town.
This line only may help your argument.
Well, it is
Injuries are not on the vital part.
not on the
And X-ray was done.
as per my advice. And I
CT was not
referred to
there.
X-ray plates at the time of treatment. Dr. Tripathi has scribed the observations with regards to X-ray plate, but Dr. Tripathi has not been examined. There
What
was
is
no
staring- what is
there
staring-
was no bony injury on the skull as per the radiologist.
That's right. But
It is not a fact that I have not examined. He has not stated the injuries are in the ordinary
see,
course.
the
of
nature of injuries are not more important. Even if it is simple,
My lord.
it's a different story. But the repeated injuries cause 14
Mal-
injuries.
My lord.
That is staring on the face of record.
Well, for that reason,
If you have no intention, why have you given 14 injuries?
it may be case of 320.
Repeated assault.
It may be
He's
case
lucky
of-
that
survive.
none of the blow is
Landed off-
touched the vital part.
Landed up in vital part.
So
that
the
is an injury.
intention how on the
325.
if it is isolated single blow or something of that sort.
It can be a case of 325. 326 of privation, 326 325.
325. But so many injuries, that's the problem.
Well, judgments are there. If I wants that, I can. If that's with all these injuries,
Multiple injury. In the
Mal-
case of
mal-
multiple injury, how will you escape from the intention part?
I'll cite this is with regards to 325.
325.
With multiple injuries, different parts of the body. And my lord, with regards to period of custody, it will be around 47 days in total. And use the lecture. What is that? Oh. আর কিছু নাই কিছু করে
Because the two elements, that is the intention and knowledge to cause death. 3 for
There may
307.
be whether intention to harm him or to cause injuries, but not to do away with his life.
Not
Because
touching
the
the
po-
vital part, not touching the vital
Yeah.
part, you are escaped from knowledge part.
Knowledge.
No problem.
Malay.
But intention part, how will you get?
Intention,
get
whether
it?
if
There is
intention,
the relationship with your sister and all.
that
this.
is that they have not stated. I have stated in my accused statement that because of this thing they might have lost a false information against me. This much. They have not stated so. They say with regards to land dispute.
Yes, what do you say?
PW2 is the eyewitness to the occurrence. Is what kindly glance at a moment. What he stated.
Yes.
That is case 41. PW2. Your Honor.
Injured.
No, he was
He was
with
the brother of the injured. Your Honor.
he was with
The eyewitness to the occurrence.
he was with PW3.
Yes.
Halela.
I know that.
Read relevant part. I had gone.
I know the accused person. The incident took place about the 1 year back in the month of
Just
just at about 11 p.m. in the premises of Ramay Takis. I had gone to the cinema hall with my brother to witness the second show. While we are returning, we saw the accused person at the gate of the cinema hall. This is my elder brother towards the Delhi market road, Raghav. That Raghav is one of the appellant.
who died.
Died. I'm there, Raghav. Raghav got told of my brother and Madhu, who is alive, appellant one, assaulted him by means of Bhujali. My brother managed to escape. I am seeking to ensure the conviction 307. Intention and knowledge and overt act also. Overt act will also what happened there was placing. The accused person assaulted by brother inside the cinema hall premises. He fell down when also he was assaulted by Bhujali. When I tried to come to this rescue, the accused person charged me to assault, but I managed to escape. My resolution also is so far 307 is sanctioned. Intention
Repeated assault.
Overt is clearly met out and corroborated by the PW2 and independent witness also.
Admitted.
PW3 is let us show you. And injuries as well as in 14 injuries are there also. Only 3 injuries.
Attributed to both the accused persons.
But in the cross examination, your plea was different. They were trying to stole something, and this is the cross examination.
ଏଠି କହିଛି PW2 ପଚରା ହେଇଛି submission ଦିଆ ହେଇଛି. I'm drawing my attention to that.
Some other witnesses also you have asked.
PW2 violate last but 3 lines.
No, even PW3,
PW3
page 45 at the top. At the time of assault, I could see the MO1. For that, I could identified. It is not a fact that I enter inside the cabin for committing the theft of articles, and that the accused person shouted. I tried to run away, but fell down, and broken glasses piece and sustained injury. This is what difference basically.
My lord.
And the same thing in PW2 also. And in 313 you make out another
PW2
story.
No. I'm talking, my lord. That is there also in the evidence of PW2, my lord Messi.
Hmm.
My lord, last but 4 lines, page 42.
Yes.
I ran away when the accused persons chased me,
Hmm.
and that we had dispute earlier for the marriage. Similar was the question to PW3. It is not a fact that above one was held by me.
Enter into quarrel when I refused to give their sister in marriage. Refused to give the sister in marriage to Ram Kumar.
My lord.
There was some altercation earlier, but it is subscribed.
Ram Kumar is
The
PW3.
intervention of the villager, I do not know. So
It is
and that day it is said that they were trying to
similarly,
steal
yes.
something and
Yes, my lord. Similarly, PW3, paragraph said page 44, last but 6-7 lines. It is not a fact that I wanted to marry Sodamini, the sister of accused, and for that there was a quarrel. There was a panchayat of the village Bhadraloks for the boundary dispute of ours
that was subsided.
subsided then and there. It is not correct to say that we came to Alangir to assault the accused persons, and I was armed with MO1 for that purpose. It is not a fact that I failed to assault the accused persons. Failed this case. But injuries has not been there, but again, I could not see
What
them.
was
What
his
for that?
age?
Hmm? Age would be around 50, 55, 56 or 55. Judgment रे अच्छे
23 years in the
23.
year 93.
हाँ
Now
2025
93.
55 56 हो
55.
50.
Yes, sir. Tell me about sentence.
But what I suggest, my lord, say
It
around
can't be 325.
well, 47 days, but fine amount may be increased. 500 rupees fine is there. So, my lord, in one case, my lord was pleased to pass order directing the injured to get the fine. Injured is dead. The court is not accepting the order. I said, you deposit it through challan in the court or any relations. My lord may add that any legal heirs.
Relations.
So that here the fine amount, maybe
Basically,
here
the fine-
fine amount is 100 rupees.
No,
It
no.
may be- it
Here
may be
5 years sentence. How much he has undergone?
Only 47 days.
47 days. Fine may be enhanced to 10,000, 15,000. Or 20,000. Subsided he given it.
No way you can find out way to reduce it to 325. Repeated injuries, multiple injuries.
Let me see some if I can get some decisions that with number of injuries whether it can be 325 or not. Day after tomorrow I'll see.
Number of injuries and repeated injuries.
My lord. If it will be there, otherwise how can we?
Okay.
My lord.
You give to that extent, I'll keep
To
it.
that extent.
First item, huh? First item.
Thursday or Tuesday?
No, Thursday.
Thursday.
Thursday, make it first item and Mr. Mahapatra's item second. Okay, I'll take it to number. Only to that extent,
Again.
if you can get. And what else? Oh, the item 10. Item 10.
I'm 13.
Hmm?
Item 9.
This is item 10.
Nine no to ten no thila se jhoti pade. हाँ करियो बोली कहथिले 10 टा किंतु 9 10 टा.
There are three appellants. Appellant number 1 and
हाँ
3,
3.
3 months, and appellant number 2, 6 months for 324. And the rest are
Already undergone 3 months.
This is a matter of Ronnie Sindar D9.
हाँ
Civil.
item 10.
Tango case ta,
Come.
chamber case. 9 time.
हाँ 10 days.
हाँ এটা তো 10.
Yes, madam.
Your Lordship, there are 3 appellants. 2 of them.
Mike.
Your Lordship, there are 3 appellants here, and 2 of them have already undergone the sentence. They were sentenced to 3 months of rigorous imprisonment. And the second appellant, he has undergone 3 months. 3 months is left. If your Lordship may be kind enough to.
Fair enough.
Yes,
Who's judgment?
ଲେଖା ହେଇଛି undergone.
Already undergone. She is fair enough. She is saying it. But you tell me what is the case.
Your Lordship,
Don't make your case so simple now.
no, Your
Tell
Lordship,
me what is the fact.
Your Lordship, there was some scuffle between the accused persons and a few other people who have registered the complaint. And all happened in a field in a nearby village. And thereafter, one person died. Hence, the present case was filed against the present appellants. And Your Lordship, thereafter, they were convicted under Section 323 IPC.
Who is
And
injured?
Your Lordship, PW4 and 6.
Wait, Mr. Das. Letter. Huh? Yes. Yes. PW?
4 and 6.
Both are injured, huh?
Yes, Your Lordship.
Okay. Just see for what does he say. Para 2, read it. Yes. Read the first paragraph.
I know the accused persons in dock. About 2.5 years back, the incident took place at a place near Duando and Mat of village Shikharpur. On the case day, myself, Surendra Behera, Uday Swai, Ramachandra Bhuya, Syama Behera, Kumar Bisoi, and Bikari Jena had been to the spot for collection of green grass. At the time, all the accused persons arrived there at 8 a.m., being armed with Pusa, Farsa, Bhali. Out of them, accused Kalia Mantri at first assaulted.
Accused Kalia Mantri. He is a accused number.
Your Lordship, he is not the accused in this case.
Okay.
He's the absconder in this case.
Assaulted Ramu Bhuya.
Yes, Your Lordship.
Ramu Bhuya is PW.
Your Lordship, he died. He succumbed to the injuries.
Okay.
That
Died, huh?
Yeah.
Died. Okay. By means of Farsa or agent.
At that time, when I rushed near Ramachandra Bhuya, accused Chabi Pradhan, assaulted by
Sabi Pradhan is PW.
Chabi
Sorry, A4, A3.
A2, Your Lordship.
A2. Okay, A2. Okay. Assaulted me by means of Farsa.
Yes, and I sustained injuries on both of my palms. When I fell down, the said accused Chabi again gave me a farsa blow on my head. At that time, accused Ullah Pada also attacked me and assaulted on my back by means of bhusa. After that, I lost my sense.
Accused Ullah Palo, not convicted. Okay. Okay.
In the incident, Surendra Behera and Bhikari Jena also sustained injuries, and Ramachandra Bhuya had succumbed to the injuries. I was examined and treated by the doctor of.
Then what happened to that Kalia Mantri?
Your Lordship, he is the absconder. He is the main accused person. However, since he was absconding, the case was filed against these 3 appellants. And there's another person who is also absconding. That is this Ullapala. He's also absconding, Your Lordship.
Ullapala.
Yes.
Absconded. Ullapala. Absconded, huh?
Yes, Your Lordship.
Okay. Hmm.
My village was at a distance of 3 kilometers.
Now, who is the doctor who examined this witness?
Your Lordship, PW 11.
This is injured. PW?
11, Your Lordship.
Doctor. Yes. Yes. PW 11.
Yes, Your Lordship.
How many injuries you received? This is Dinabandhu Viswai. Under my treatment, Dinabandhu Viswai.
Your Lordship, all injuries are simple in nature. That is the observation given by the doctor, PW 11. All the injuries were simple in nature and were probably caused and prior to my and caused 6 hours prior to my examination.
So 324 because you have used farsa.
Your Lordship, although that is the allegation, however, no MO has been seized in that regard, which makes the prosecution case doubtful.
Farsa not seized, huh?
No, Your Lordship, none of the weapons has been seized, which is why the allegation.
See, if you read the PW 11, he says that the incised wound
Yes,
have
Your
been
Lordship.
caused by farsa, and injury number 3 can also be caused by bhusa. Exhibit 3 is the injured report. Don't show. Who is Vikari? Vikari Jana is PW 6.
Yes, Your Lordship.
PW 6, na? Huh?
Yes, Your Lordship.
PW 6. Let us see PW 6. He also sustained 5 injuries. Let us see PW 6. What does he say? Down to PW 6. Yes. At the time, all accused persons came together by Busa, so and so, so and so. They came and said, "This is Samu here." Thereafter, Kalia Mantri gave a farsa blow.
If Your Lordship may take a look at para number 7 of PW 6.
But this PW 6 doesn't say anything about PW, appellant number 2, Chabi.
No, Your
It
Lordship.
only says about Uday.
Yes, Your Lordship. But then he was running away while he was attacked, and thereafter he fell on the ground. So basically, my contention is that he did not actually see who attacked him. So whatever statement is made, it is made on the, it is made, it is like he assumed that Uday attacked him, but there is no other evidence to corroborate the same. Especially after he says.
But very the allegation against Biswajit. Neither PW 6 nor PW 4 has said anything about Biswajit.
No, Your Lordship.
So why are you not pressing for Biswajit's acquittal?
Your Lordship, pardon me, Your Lordship.
Biswajit, the third appellant.
Yes, Your Lordship.
Biswajit Pradhan. Biswanath Pradhan. Biswanath Pradhan. Sorry, Biswanath Pradhan.
Yes, Your Lordship.
None of the two injured,
Yes, Your Lordship.
PW 4 or 6, have said anything about him.
No, Your Lordship. And also with regards to even.
No, yes or no?
Your Lordship.
Have they said anything about?
No, they
Because see,
haven't.
PW 4 doesn't say anything. Yes, Mr. Das. Let's see, PW 4 only speaks about the assault made by Chobi. Okay, that correspond to 324 as per the doctor's this thing, because he used Fatha. Okay, PW6 says that it is Uday who has given him the blow, which is a simple injury. Therefore, 323 for Uday. What about Biswanath? PW 5. Okay. Yes.
I know the accused first, the next is the 81 pages. 80 pages in period 5 second paragraph.
Yes.
While we are collecting the grass from the field, all the accused person came there with armed with lathi, bhali, farsa, bhusa, effect, and attacked us saying as to why we are collecting grass from the area. What of the accused persons? Karya Mantri gave a farsa blow on the backside head of the deceased Ramchandra. I also noticed Urla Pala. Assaulting Ramchandra by means of lathi, seeing the Dinabandhu, lost near Ramchandra, also gave him further assaulting while.
We are not concerned about that,
Yes, sir.
because that is their option.
Yeah, Shabi gave further the head of the Dinabandhu fell down. She tried to run away, but I was assaulted by active BCA. A BCA officer, Vishwanath.
I was assaulted by accused Bishia by means of lathi on my left leg. On my left leg, okay?
Yes.
On my left leg. Come to P11. He is, what is his name? He is, no. The witness is Surendra. Let us see PW11. Come to P11. Is there any injury on the leg?
Your Lordship, Lordship,
Left
it's
knee.
been medically
Left knee there is a injury.
examining.
What?
Your Lordship, he has not been medically examined.
Hmm?
He has not been this Surendra person. He has not been medically.
Surendra, so Surendra is not examined.
No, Your Lordship, he has not been examined.
Oh, I got.
From the video.
Oh, that. Whether it is simple, grievous, how do you know? How do you know?
Very simple, kind of border around it.
Where is the corroboration?
Say that the night.
Your Lordship, even with regards to Chabi, there is no other corroboration. It is only the conviction is.
Like Chabi, the PW4 says Chabi has given
Yes,
the
Your
blow,
Lordship, but
and that stood corroborated with the PW11.
Yes.
Injuries are there.
yes, Your Lordship.
But insofar as Vishwanath is concerned, there is nothing.
Your Lordship, I am not denying the injuries. The injuries are definitely there. My submission is that who caused the injuries, that is uncertain. Just keeping in mind the facts and the evidences that we have right now. Because first of all, no MO has been seized with this regard with regards to all the injuries that have been caused. And also the prosecution witnesses
Who is this
themselves.
Vikari Jana? Who is that Vikari Jana?
Your Lordship, he is also injured. He is also injured person.
Injured.
Yes, Your
Which
Lordship.
witness is he? Huh? PW6.
Yes, Your Lordship.
No. PW?
6, Your Lordship.
Yes. But that PW6 has not PW6, okay. But he doesn't say anything about what you call Vishwanath. Neither PW6 nor PW4. তাকে তো মেডিকেল এক্সামই করনো তাহলে তো বই
Your Lordship, 30 to 40 people.
His statement will corroborate with whose statement? Find out corroboration. Yes, madam, what do you want to say?
Your Lordship, my another submission is that there were around 20 to 30 people who apparently attacked all these people. And
Where
TI
you are getting that story?
Your Lordship, PW4 has himself stated this.
PW?
PW4,
Oh.
about 15 to 20 persons of village Sikharpur.
PW4 where you are reading?
Your Lordship, Para 9.
Para 9, huh? Yes.
About 15 to 20 persons of village Sikharpur, including the accused persons, had arrived at the spot. However, Your Lordship, no TI parade has been conducted, and
Sorry, madam, I didn't get Para 9, na?
yes, Your
It's
Lordship.
not a fact that I stated before. Read it once again. Yes.
It's not a fact that I
It was
stated.
already plugged. By then, about to 15 to 20%
Of
the
village.
village Sikharpur, including the accused persons, arrive at the spot. We saw first these accused persons of distance about 150 meters. They came in a group. Yes. Yes. According to me, appellant number 3 is entitled to acquittal. Panchano, tell me the corroboration.
Seen this person, including 30 to 40%, he's seen this person and trying to attack.
Don't go to that area. Then she is raising another point. So many people were there. Out of 20, 30 people, how have you identified them? There is no TI parent, nothing. That's,
One village. So he knows it.
he knows others also.
Maybe they are not meeting.
So then you can see, unless a group of person comes, unless specific overtake is attributed to someone by the injured witness, how will you nail down to them for these offenses? Very difficult.
The injured persons, they are saying who hit him, that is only this persons only.
But then, Your Lordship, there is also no MO that has been recovered to corroborate the same, only based on.
Now, madam,
based on-
do one thing. You argued very well, but prepare a note of argument, give it tomorrow.
Yes,
Aiming at whatever I'm saying. Let her do it.
Yes.
A written note of submission by tomorrow evening.
so-
Page 37. Page 37
That's the.
Your Lordship, Your Lordship, accused number 1 and 3 both supposed. Your Lordship, both deserve to be acquitted because there is no.
You are making
there
them
is-
wiser.
Your Lordship, there is no. Your
Anyway,
Lordship,
if
there is
that
no
is-
corroboration.
If that is your case, after conceding also I am reading it. Otherwise, I would have closed it. Right?
Yes, Your Lordship.
Since you are making an effort, prepare a written note of submission. Why every accused? If they are entitled to acquittal, why not? Acquittal. If they are not entitled, well, that's a different story. That as you said that they have already undergone. On that ground, it can be disposed of. But if they are entitled to acquittal, let us keep that. Prepare it and give by tomorrow.
Yes, Your Lordship. I'll do that.
Prepare detail and the evidence of every witness. Yes, good.
Oblige, Your Lordship.
So first, every time you don't straight away concede. You try, if the court is not agreeing, then you concede. First you started with conceding yourself, no, do it like, no. First you try, if the court is not agreeing with you, then that is the secondary point. If you are entitled to acquittal, why will you concede?
Yes, Your Lordship.
So therefore you prepare a very good note and give me.
Yes, Your Lordship. Oblige, Your Lordship.
Yes, Mr. Mishra?
Item 9.
9, yes.
Convicted my lord. 1 year imprisonment. Convicted for offenses, my lord.
How many of them are there?
2, my lord.
One had died. No, nobody is died. No, both of them are dead. Yes.
Page 92, my lord. That judgment.
And page
92 of the TCR, my lord. Judgment page is 21.
judgment by
Case number 21.
21 of this paper book. Which paragraph you are talking?
Paragraph 19, man, the convictions.
Yes.
In the result, both accused persons are found guilty of the charges under section 318 of the SCATS Act, read to section 34 of IPC, section 323 and 450 of IPC. They are found not guilty of 307 as well as 32D of the Act.
Yes.
The case is based on the evidence of 1, 3, and 5.
1, 3, and 5.
1 is the informant himself. The incidents took place in the house.
PW1 informant.
Yes.
PW1 informant. Yes.
PW3
PW3
and PW5.
Who is PW3?
PW3 saw the occurrence inside the house.
Witness. Eyewitness.
Yes.
And PW5?
5.
Who is he?
He is also an eyewitness.
Eyewitness.
The occurrence took place inside a house, and these 2 persons into the eyewitness.
Okay. What was the occurrence? Let us see. Here. PW1. Let us see PW1.
The chairman of Gunpur Panchayat Samiti.
I was also the chairman
Yes,
of
chairman.
Gunpur Panchayat Samiti. I am a Sora by caste and a member of scheduled tribe. At about 9 p.m., I was in my house.
I was in my house.
Gunpur Panchayat has
Jurisdiction over
the
native
jurisdiction over the
village.
native village of Titlimiri, village of so-and-so, my native place. At about 8 to 9 p.m., Bhaskar Padi and Harakrishna
Marapuri of village
of my village came running to
both
my
of
house.
them had injured in their
Both
hands.
of them had injury on their hands. They told me that at the
At Gunpur
Gunpur
bus
bus
stand,
stand,
both accused
both
persons
persons called them to push
to
their
their
vehicle
and
and their refusal, both of
from their
the
refusal,
accused
both
persons
accused persons
assaulted them.
assaulted them.
And they
Then I
went
went
to
put case from my house to
so
tell
from my
advocate
house
Hon'Ble Patnaik
to
of
tell the
Gunpur,
advocate Poni Bhushan Patnaik of
who is also the
Gunpur,
president of motor vehicle,
and who is also the president of
motor
Motor Workers Union Gunpur. And it was I was told him in the
chamber about
chamber
this incident.
about this incident.
He advised
He
me to file
advised me
complaint
to
at the
file
police
complaint
station.
at the police station.
I without going to the police
I,
station.
without
returned to my
going to the
house.
police station, returned to my home.
house.
Thereafter, at about second incident, 9:30
For
to
this
10.
matter, charges have been paid.
Huh?
For this occurrence, charge has been paid. This occurrence at night, that 9:30 to 10 p.m.
That is 323 and whatever.
No matter that, so SCST has charged the occurrence took place in the night, the paragraph 3 matter.
Let us see. Thereafter, at
Yes,
about 9:30 to 10 p.m.,
Again,
again, I came to the town to collect the information about the incident.
incident. I
I
came
came
to
to
Katikya side,
Katikya
crossing
side,
the
to
Gurupur
cross the
and
Gurupur,
went towards the bus stand.
towards the bus stand.
I met both the accused persons at the bus stand and asked them as to why
Asked them
they
to
assaulted
why
Padi
they
and
were
Nirmal
assaulted.
Puri. Both the accused persons started abusing me, saying,
So,
yes, yes, yes. Still I pursued them. Saying, after that matter, still I pursued them
still I pursued them politely.
saying that the injured persons belong to our area and they should not be dealt with in this manner. Then they accompanied me to Katika Street, crossing again, telling me, as Katika, both the accused persons started assaulting me, dealing fist blows, slaps, and boxing. I sustained bleeding injury on my mouth and swelling at my back. To save my life, I ran towards my house. They caused of me of a certain distance, but I fled away to my house. At about midnight, myself and Padi, Nimalpuri, Vidika Turkana, and some Samiti member of Ghatal Padar were sitting in my house, and I was thinking to report at the police station. Suddenly, both the accused persons entered into my house. Vidika Turkana was at the doorway of my house. Both the accused persons entered inside my house, assaulting him.
Accused Venkat Rao.
Accused Venkat Rao
dealt-
dealt a kick to me, to my chin.
This
abusing
is the
me.
third incident
Yes.
in the day. Sora and
Then both accused persons assaulted me, dealing fist blows, kick to my face, hands, back, other parts of the body indiscriminately. Both of them also pressed my neck to kill me. At that time also they were abusing me, filthy language as before. I somehow came out of their clutches and entered inside my front door neighbor's house, Uday Patnaik. Uday was absent in the house at that time. One Khottu was in that house. His good name is Bhuvanananda Patnaik. He was standing in the front room opening the front door. Thereafter, the accused persons became to abuse me. At that time, it was about 1 to 1:30 a.m. There was bleeding from my face, and due to assault, my physical condition didn't allow me to go to the police station in the same night. Bhuvanananda in the same night came to the house of Advocate Prakash Rao, the then president of Gunpur Bar, to inform the police station over phone. Then Prakash Rao came to see me. I also narrated the incident before him. Then he went and ran to the police station. In the next morning, I went to the sub-collector's residence and submitted a written report to him, who forwarded the same to the police station. This is what report exhibit 1. This is the endorsement with the signature of the sub-collector from SDM Gadadhar Parida. This is my signature and others accompanied to the sub-collector's residence. I was medically examined on police accusation. I felt humiliated having been abused and assaulted by the accused persons being a member of the scheduled tribe. My wearing check set got torn in course of the assault, which has been seized by
yes.
the
Let us see 3.
2 is the declared on hostile manner. Widow 2.
3 is witness to which incident?
I know Bidol 1, both are the occurrence took place about that matter 11:30 to 12 midnight.
Last incident.
Last.
First 2 incident nobody is
Nobody.
witness.
Neither
Last
has been-
incident only.
Neither has been reported to the police matter. In the house of the Pidol. This occurrence took place in the house of the Pidol 1 within the 4-wall matter. At that time, Pidol 1 returned to his house with bleeding and he told me that both the accused persons assaulted him. That means this is a post-occurrence witness. Because he is saying that Pidol 1 came to his house in a bleeding condition. Then he sat with a paper to write the report about this incident to the police station. At that time, Bediga Tukuna was sitting in the pinda of that house. Both accused persons assaulted him and entered. Yes, yes, ma'am. Assaulted Bediga Tukana and entered into the house of the Pidol one. Accused Picha suddenly dealt a kick on the chin of Pidol one. He also abused Pidol one, saying, Sora, Ethara Banchi Balu. So saying, he pressed the neck of Pidol one. Picha. I have not seen accused Virisinu assaulted PW1.
He is post occurrence witness.
Yes.
PW5. PW4 is the doctor. Huh?
Doctor. She said abrasion, contusion, abrasion. All the injuries are simple in nature and caused probably by blunt weapons. Age of the injuries is within 20 hours of the date of the examination at 11:30 am.
The injuries can be possible by the first week.
1992. This injury can be possible if a man rolls down and his neck and body can come contact in with the stones and rough subjects. Injury number 5 and 6 can be self-inflicted or be by friendly hands.
PW5 is the Bhaskar Padi who was assaulted in the first incident.
On that day, I had come to the house of Pidol 1 along with Hare Krishna Nimalpuri. At about 9:30 p.m., Nimalpuri and myself came to the house of Pidol 1 and came to the bus stand to go to our village. At the bus stand, the van driver accused Picha asked us to push the van. Since we are holding articles in our hands, we refused to push. Accused Picha then told us, we told that we were holding articles and we were feeling weak, for which we could not push. This Picha is the van driver, madam.
Number 1.
We could not push. Then accused Picha told.
Picha is accused number?
1.
Madam.
1.
Interestingly, I found that he is apprehended on 10/9/92, but bail bond has been filed on 1/16/94. In more than 2 years.
When is judgment? Bail bond is after judgment.
Date of the judgment.
Judgment is 94.
Yes, madam.
94. 16/9/94.
Incident, let us see, undergone period.
Apprehended 10/9/92.
10/9?
I have a glass of 152, page 152.
123 টা দেখি। 123
That calendar period.
TCR 152.
152, my lord.
Yes,
Date of arrest of accused 10/9/92. This is in respect of V. Venkat Rao.
Current statement, let us see, date of occurrence is na, date of
8/9/92.
receipt of fire, so date of arrest of the 10/9/92.
This is in respect of that picture V. Venkat Rao.
Uh-huh.
V. Venkat Rao. Friend number 1. Then the co-accused arrested, surrender on 4/11/92. This is Sinu.
So A1 arrested
10/9/92.
10/9/92. Huh?
Yes.
Bail and A2 arrested.
So 23 take result placed.
4 surrender. He is
Surrender,
surrendered. 4/11/92.
4/11/92. Let us see the bail bond.
Bail bond married to 309. $16,994.
What is the pace?
309.
309. Seven 94. Huh?
16th September 1994. The bail attend the court this order. You are directed to attend the court 7/10/94. 1 year.
1 year.
Okay. 6994.
94.
Bail bond. Both of them, huh?
Yes,
No.
ma'am.
No, that's clear. Best of the clear.
Just check it up for the order.
In the charge sheet, my lord, it is written nil, whether in bail or case 19.
123 is the code. Page number 123. That's good thing.
No, but see, proceeding of the trial court, 6593, both the accused persons are present on call. And by that time, they were already on bail. Huh?
Eight 193 date of commitment को से जो order लिखा है active prisoner on bail.
Huh?
8193 digital page 4 रे तो लिखा है सी the commitment है तो लिखा है active prisoner on bail and have been directed to appear on 48 त्यान 8 त्यान order number 1 sessions case number 352 that is 4.
3 number question, 4 years, madam. Letter notifying commitment, calendar statement, explain for delay in commitment.
First para last 2 lines ago.
Proceeding dated?
Order dated 8193 also. First para the last 2 lines is relevant. The committing magistrate reports that the accused persons are on bail and have been directed to appear on 2199.
They're on bail. That's
आठ एक ध्यान में तो on bail थिले जो दिन में नॉन एक्सप्लेन कुछ 92 रे 10 नो अरेस्ट रही थिले 10 नो बयान है
Pehले 4 months.
सेटलमेंट बुझो है जो देखियो
केबे bail लगी जोड़न ना?
That is good, huh?
Not much out of it. What is the sentence?
1 year.
1 year. 1 year.
मैंने 21 93
Hmm?
my lord may find in 150 55 my lord 156
What do you want to?
that Beller we Gauri Sharma propose
When?
willing to continue Beller it is on 20th January 93
3 months old.
January?
93
20th January. Then 1 month, 2 months, nothing.
my lord in that in 15/12/92 that calendar statement it has already been known the accused persons are on bail my lord that means in this
1 month. But see, 313 statement.
Commitment ହେଲା ଯୋଉ DDI ହେଲା explanation ଅଛି 153 page.
It's all right, I got it. 1 month or something. But see the statement, 313 statement.
Madam, page 61. Political ବିରୋଧୀ ହେତୁ ମିଛ କେସ୍ କରିଛନ୍ତି
The question number 2 is pertaining to, there are 3 incidents happened. In the morning and afternoon and night.
Night, madam.
Okay. Insofar as the entire offense is regarding night incident.
And charge also framed in that night occurrence.
Night occurrence only. But see, 313 just see question number 2 pertaining to the morning incident.
Yes, Bhaskar Padi.
Okay. And for question number 3.
He and Hare Krishna started running and you
Same morning
chase-
incident.
chase them.
And 4 also morning.
Yes.
And in the afternoon, 5 is regarding afternoon.
Afternoon. 7 is regarding night occurrence, madam.
And see the utterances in question number 5. The utterances which were put to nothing, he has not said anything regarding the car.
Trust.
Okay? Come to 6.
Dealing fish close, slabs, boxing, and yes, they both selling in a certain distance, but
Only question number 8.
and
That too, appellant number 1 has uttered this sentence.
that picture.
Not accused number 2.
One is there. Picture.
This is the statement of that picture, and other is the Hanford Rao. This is picture. This statement.
Yes. Yes, madam. insofar as accused number, there are 3 incidents.
Yes, madam.
Insofar as the third incident is concerned, the FIR is relatable to that.
Yes.
Evidence is also laid in that direction. But insofar as the appellant number of 1 is concerned, there are some attributions.
Yes.
But accused number 2 is
Well,
concerned,
nothing, madam.
there is nothing, no abortage is attributed. Except saying that both of them have beaten him, kicked him and all.
In the judgment portion, madam, the paragraph 8, the Rodent was summarize the statement feudal 1. There is nothing regarding caste, madam. Paragraph 8 of the judgment. Rodent transport quoted the statement of feudal 1. Nothing regarding caste or tribe. Only abuse.
Abuse. PW 1, huh?
1.
Which paragraph?
8. Judgment paragraph 8, madam.
But here he says, na,
Yes.
in evidence.
Feudal 1.
Evidence he says.
Feudal 1 is now, my lord, 68.
Para 4 in the evidence, he says.
Midnight might.
There he is very categorically says, accused Venkat Rao,
Yes.
alias Picha, dealt a kick to my chin, abusing me, so and so Sora.
Dealt a kick to my chin.
Thereafter he says that both the accused persons have assaulted me, dealing fist blow and kick blow and all. How will you make out a case against accused number 2 under section 31X? If 31X goes, then what remains? One year on each count.
Yes. Those advocates also has not been examined.
Otherwise,
And the London trial court disability defense witnesses. 2 DW are there. That since they are not substituted witness.
Who is doctor?
4 men.
4.
What 4 says?
Nothing about chin.
Hmm?
Over the right axils, over the left scapular region, over the right chest,
Only the
right shoulder.
opinion is, though the injuries in Exhibit 2 opens that all the injuries are simple
Yeah.
in nature and might have been.
Is there
caused
any
within 24
is there
hours.
any weapon use? Huh?
Slap and injury 5 and 6 can be possible.
No,
Respect of
what is the
no.
allegation? Weapon use?
No, man.
Blow, kicks and slaps being possible by pressing the neck.
Fist blow, slap, that is boxing. And the doctor says that blunt weapon. Huh?
Regarding the night occurrence, no open of open there, madam. Arpit Bangkok has kicked my chin,
Only no weapon used. by-
assaulted my fist by fist blows, kicks, hands, back and other body.
I think accused number 2,
Yes, ma'am.
that is Srinu.
Renu.
is entitled to an acquittal. Insofar as Venkat Rao is concerned, his conviction is to be affirmed.
But he is now 68.
What to do? This is what the evidence conveys.
The delay in lodging the FIR is one more aspect.
How much delay?
The 2 to 3 occurrence, the incidents happened, but FIR was on the next day. He went to the sub-collector office and the sub-collector write a report, same forwarded to the police station at paragraph 6 of the Pugal 1 matter. In the next morning, I went to the sub-collector office and submitted a written report to him, who forwarded the same to the police station.
You prepare a small note.
Sorry, madam?
Prepare a small note and give me. Argument heard. Argument heard. The parties are direct to file the written note of submission. ठीक है? हाँ? Tender कौन थी? Kan de rako to. Bisa review.
No, I may permit to take this in the pen drive now.
Yes, yes, of course. Continue. Yes. Rest of matter. Yes, madam.
Humble request to Lordship. Lordship, item 37 may kindly be taken at 2 p.m. on Thursday, Your Lordship.
Thursday we see in Thursday. We'll see on
Lordship,
Thursday.
the ailing health of the appellants, they are
Okay, 2 o'clock because Thursday I have fixed 2 matters in the morning.
yes, sir.
We'll go on for a little longer time.
Yes, Your Lordship.
So therefore, obviously 2 o'clock. Yes, yes, sir. Okay.